the BC Civil Liberties Association has won an early victory in what could become a precedent-setting case that asks the federal court to rule on whether the Canadian Security Intelligence Service can spy on activists and whether its review body has the authority to issue gag orders to complainants. The civil rights group obtained documents under federal access to information laws in 2014 that it says show CSIS was illegally spying on activists involved in protesting the now axed Northern Gateway Pipeline, in particular, the Sierra Club of BC, the Dogwood Initiative, and Forest Ethics Advocacy. It also alleged that CSIS then shared the intelligence it gathered with oil industry partners and the National Energy Board, the arm's-length government body tasked with approving energy projects like pipelines. Read more, CSIS helped government deal with Northern Gateway protests. CSIS denies the allegations, but the civil rights group filed a complaint with the Security Intelligence Review Committee, CIRCL, in 2014, which kicked off a round of secret hearings that lasted until May 2017. That's when the review body dismissed the complaint and extended a gag order it had put in place over the hearings to permanently ban the BC Civil Liberties Association or any of the groups involved in testifying before the hearing about anything they had heard, presented or learned while there. It also banned the group from disclosing that a decision into the complaint had been made at all. Much of the evidence that was presented by CSIS during that hearing remained secret and was not made available to the civil rights group or their lawyer. But in a court conference that took place last month, the BC Civil Liberties Association won the right to have that information disclosed to them during their appeal at the federal court. There was a lot of evidence CIRCL relied on that wasn't even disclosed to us, said Paul Champ, the lawyer representing the civil rights group on the case. It looks like now we will get that stuff, but it has to be reviewed for national security, so it will be redacted. However, there are still plenty of potential problems ahead before arguments can actually be made before the court on the case. That likely will not happen until this time next year. We're having some tussles about whether the hearing at the court itself can even be public and whether we can file our evidence in the court record in a public manner, said Champ. By doing so, arguably, we're in violation of the CIRCL gag order. The BC Civil Liberties Association is asking the federal court for two things. First, the group wants a ruling overturning CIRCL's dismissal of their 2014 complaint and ruling that the monitoring of environmental activists by CSIS and its alleged sharing of information with external parties is illegal. Second, they want the federal court to rule that CIRCL was wrong to interpret Section 48 of the CSIS Act as allowing for a ban on discussion or disclosure of hearings and rulings made by the review body. Whether the court rules in favor of CIRCL and CSIS or the BC